Welcome to this explainer. Today, we are going to build your legal analysis skills from the absolute ground up. We're merging the foundational mechanics of reading case law with the advanced strategies for case and rule synthesis into one comprehensive episode. So let's dive right in with a massive question that every single law student and legal professional faces. You know the feeling, staring at a stack of judicial opinions so heavy it literally threatens to break your desk. How do you turn that mountain of dense case law into a single, cohesive, winning argument? It can feel completely overwhelming, but the truth is, it's not magic, it's architecture. To build our structure, we're going to cover reading legal precedent, the anatomy of a case, levels of abstraction, analogizing and distinguishing, and finally, the art of synthesis. Let's kick things off with Section 1, reading legal precedent and shifting your focus. There is actually a pretty stark contrast between how you might read for a doctrinal course versus how you read for active practice. If you're sitting in a doctrinal class, your goal is broad. You're tracking how legal principles evolve over time, trying to understand the underlying policy, and playing around with hypotheticals. But when you shift to legal writing and actual practice, your lens dramatically narrows. Suddenly, your sole focus is predicting how a court will rule on one very specific client problem. You have to hyper-localize your analysis to your specific jurisdiction. Section 2, Anatomy of a Case. The blueprint. To navigate these decisions, you need to know exactly what you're looking at in a reporter. First up is the caption, which simply names the parties and the court. Next comes the synopsis. Now listen closely here because this is crucial. This is a publisher-provided summary. It's incredibly helpful for a quick overview, but you must absolutely never cite or quote it. It is not official authority. Below that, you'll find headnotes, which are just classified summaries to help you research similar cases. Then we have the attorneys and the judge. And finally, we reach the actual opinion. This is the gold mine. This is where the facts, the procedural history, the analysis, and the actual holding live. Moving right along to Section 3, levels of abstraction. Breaking it down, by separating a case into these 4 levels of abstraction, you can isolate exactly what gives a precedent its binding authority. First, think about the issues. How you define the legal question changes everything. Characterizing a plaintiff as a grandmother who did not live with a victim creates a very different scope than simply calling her a close family member. Then you look at the facts. Which specific details actually moved the needle for the judge? Next is the holding, the ultimate legal rule of the case, which can be framed narrowly to apply only to these exact facts or broadly to cover future disputes. And finally, reasoning and policy. This is the why. If the social or economic policy driving a prior decision doesn't fit your current dispute, well, that precedent might not actually control your outcome. Section 4, Analogizing and Distinguishing, the bricks and mortar. This right here is the actual bricks and mortar of legal advocacy. The crucial point is that you only distinguish when the factual differences are legally significant and directly influence the underlying legal rule. If your client's facts match the precedent, you analogize, you tell the court, look, these situations are identical, so you must apply the same rule and give us the same outcome. But if your facts are different, you distinguish, you argue that the disparities are so significant that they demand an entirely different rule or outcome. Just be careful, don't distinguish over trivial details like the color of the plaintiff's shoes. The differences have to actually matter to the underlying legal policy. And mastering this matters right now. To hit a level 3 on your academic grading rubrics, you must perfectly execute these exact mechanics, correctly analogizing and distinguishing all applicable facts while providing a full explanation of the precedent court's reasoning. This isn't just theory. This is exactly how your legal analysis is being evaluated. Section 5, the art of synthesis. Building the roof. Synthesis is the ultimate goal. It's how you weave multiple, sometimes conflicting cases into one cohesive governing framework. In the real world, you are rarely handing a judge just one case. You're handing them an entire line of precedents, and you have to synthesize them into a single narrative. This systematic approach relies on a neat 2-part framework. First, rule extraction. You go into each individual case and pull out the accurate legal principles. Sometimes the judge hands it to you on a silver platter. Other times you have to read between the lines of their rationale. Once you have the rules, you move to step 2, collective evaluation. You lay out all the rules, material facts, and final outcomes across your multiple cases and start hunting for patterns. Let's try charting this out using parental tort immunity as an example. This visual charting method is literally what practicing attorneys do to map out complex multi-case strategies. Consider the Abbott case. It's a negligence suit, involves a 12-year-old minor, and the father is immune. Now compare that to White. In intentional battery, a 10-year-old minor, and the father is not immune. Finally, look at Black. negligence, but a 24-year-old adult and the father is not immune. By lining these up, the variables dictating the legal outcome start jumping right off the page at you. From that first batch of cases, we can extract an initial synthesized rule, isolating negligence and minority status as the key variables for immunity. We see that a parent is immune from a negligence suit by a minor, but parents are not immune from intentional tort suits, regardless of age. Simple enough, right? But the law rarely stays that simple. Let's introduce 3 more cases: Peep, Smith, and Anderson, which forces to account for adult dependency. All 3 of these are negligence cases involving adults, but the results are split. In Peep, a 19-year-old dependent living at home results in parental immunity, but in Smith and Anderson, where the adults are self-supporting or married and living away, the father is not immune. The pattern shifts again, and suddenly our previous rule is way too narrow to capture these new facts. So we synthesize again. Here is our final, cohesive governing rule. We've combined Phase 1 and Phase 2 into a single, flawless statement. It captures the minor distinction, the intentional tort exception, and the new dependency exception for adults. It is perfectly framed, not too narrow to miss the larger principle, and not so broad that it loses its analytical punch. This is the absolute pinnacle of case synthesis. You've laid the foundation, put up the pillars, and built the roof. From pulling apart the anatomy of a single case to charting matrices of complex precedent, you now have the exact mechanics needed to command the law, rather than letting it confuse you. The only question left is, now that you have these tools, how will you frame your next legal argument? Think about how you can use this systematic approach the next time you are staring down a mountain of judicial opinions. Thanks for joining me on this explainer, and I look forward to exploring our next topic with you.